Hey, Push Nation, welcome in. Hope you're having a great weekend so far. It's casual here today because it is the weekend. Thankfully, we got the long weekend, in fact. So plenty of time for you guys to get your studying in for the reading quiz on Reconstruction this Tuesday. Also, please pardon my voice is a bit more hoarse today. It was a pretty intense basketball game on Friday night. Unfortunately, we did not win against our rivals based at Scottsdale, but plenty of season left for the Bobcats. Anyways, let's get down to business. A theme we established on Friday is how during Reconstruction, the radical Republicans' effort was stymied by the Supreme Court in one pivotal case involving members of the Colfax Massacre, and that was U.S. v. Cruikshank from 1876. The Supreme Court, for whatever reason, was thrust into the spotlight here on account of numerous 14th Amendment Reconstruction cases. And these don't all relate to African American rights. And that's really what the focal point of today's Fireside Chat is going to be. I'm going to kind of give you some cases to be aware of. But really, it's the larger theme at play here, which is the fact that the court system was yet another blockage of the Reconstruction efforts led by the Republican Party. The Supreme Court especially denied opportunities for growth in Reconstruction throughout these cases. And the first I want to talk about has to do with economics, actually. There were a series of cases in the early 1870s that were known as the Slaughterhouse Cases. These were cases that were built by various corporations in the state of Louisiana. Surprise, surprise, we're in Louisiana again with another sort of Reconstruction issue. In Louisiana, the state government had allowed for the development of a monopoly in the slaughterhouse industry. One corporation had begun building a monopoly. Its competitors sued on the grounds that their 14th Amendment privileges and immunities were being violated by the fact that the state government had set up some sort of a monopoly for a slaughterhouse business. The court interpreted this case, and really the question comes down to whether or not the rival corporation's rights were being, 14th Amendment rights were being violated. And so here's ultimately what the Supreme Court said. No, the 14th Amendment does not protect businesses from having an opportunity to compete for economic privileges and immunities. That's not what the 14th Amendment was designed to do. The 14th Amendment was designed specifically to guarantee national citizenship for African Americans. That was one of the more important clauses. Due process and equal protection, that has nothing to do with the right to compete for business contracts. And the court essentially reaffirmed that equal protection was, again, designed with African Americans and to avoid laws that discriminated against African Americans. It had nothing to do with monopolies. And so basically, the slaughterhouse cases, like I said, there was a series of these cases. The slaughterhouse cases are important to be aware of because it ties back to the 14th Amendment. And in this case, while it's not necessarily a Reconstruction Amendment, it was directly involved with the 14th Amendment, and it will have precedence moving forward as the government in the late 1800s and early 1900s begins to fight harder against monopolies, which we will be talking about the growth of monopolies and big business in the next couple of weeks. Now, let's pivot off of an economic case with the slaughterhouse cases, and let's look at women's rights. One of the more important questions about Reconstruction is, with African Americans gaining all these privileges, especially African American males with the right to vote in the 15th Amendment, what about women? And not just African American women, but white women. Throughout most of our journey this year, we've talked about how African Americans and women aligned their causes on a similar path. But when African Americans received a bulk of the amendments and privileges and citizenship rights and voting rights, during Reconstruction, the women's rights movement was truly alienated by the federal government, or felt alienated by the federal government, I should say. And this is where the women's rights movement and the African American movement started to splinter, because no longer did women, especially white women, feel a sense of protection by the federal government. And the question becomes, well, why are African Americans being taken care of but not women? And so through a series of lawsuits in various realms of American society, women began to challenge and go after their own rights via the 14th Amendment. So I'm going to give you three cases to sort of be aware of that come during the era of Reconstruction and deal specifically with women. The first is Bradwell versus the state of Illinois. Myra Bradwell was a woman who basically was denied the right to get a license to practice law in the state of Illinois. She was denied that right by the local Illinois Bar Association. So Myra Bradwell sued on the grounds that the 14th Amendment protected her rights to get a license to practice law. What the Supreme Court ultimately said was no, it does not. While all citizens do get certain privileges and immunities within which individual states cannot take away, nothing about the 14th Amendment protects a person, especially a woman in this case's right to practice law. And that's a privilege that the government is not there to protect. And the ruling here was almost unanimous. It was 8-1 in favor of the state. Furthermore, the Supreme Court justices who argued this case really stuck a nail in Bradwell's case by further extrapolating their argument in that really women and men, if you Google this and you find the briefing, that women and men belong in, quote, respective spheres. That was terminology used in this case. And the justices went even further, talking about duties of motherhood and a wife within society that related even back to religious grounds. So Bradwell's case was a major step back for women in terms of being able to utilize the 14th Amendment. And again, this was a real knock on that ability to fight for women's rights in this particular area. Another case that involved women launching a bid to utilize the 14th Amendment was Minor versus Happersett from 1875. Minor versus Happersett. Another female was attempting to utilize the 14th Amendment, specifically privileges and immunities. And here, in Minor versus Happersett, the issue came down to whether women could use the 14th Amendment to gain the right to vote. Ultimately, the Supreme Court, once again, said no, that's not what the 14th Amendment was intended for. It was more intended to protect the rights of African Americans. So this is yet another blow for women in the attempt to gain privileges and immunities via the 14th Amendment. But maybe the most famous of these cases in which women were denied rights in Reconstruction is U.S. versus Anthony. And in U.S. versus Anthony, the Anthony is a quite familiar name for many of you because it's one of the most famous women's rights crusaders of all time, and that's Susan B. Anthony. Susan B. Anthony was arrested in New York State in 1872 for trying to vote for Ulysses S. Grant in the 1872 election, which Grant would win, by the way. And Susan B. Anthony was arrested, so she sued, saying that her rights, of course, had been violated. The court, again, threw Anthony's case out as far as giving rights to women. Susan B. Anthony lost the case, did not receive any protection or anything like that. So again, continuing in our theme here, this is yet another step back for women's rights. But Anthony's case really is, and I'm going to put up a quote here from her, and I think a lot of you may be able to draw some inspiration from. I know I can certainly. So Susan B. Anthony's case drew a lot of national attention because she was a woman of great stature and clout. And, again, where we leave off here is essentially another element to the story of Reconstruction, which is that the 14th Amendment was such a sweeping, broad, massively game-changing amendment to the Constitution. And under the pressure of Reconstruction, the Supreme Court often folded. And the Supreme Court did not take opportunities to advance rights for other groups, but it stayed in the realm with African American groups. And so, really, to recap, there's a series. You should know the Slaughterhouse Cases, Bradwell versus Illinois, U.S. v. Anthony, Minor v. Happersett, and the last one, of course, is what we talked about in class on Friday, the Cruikshank case. So we did some Supreme Court stuff today. On Tuesday, when the reading quiz is over, we're going to focus on doing some writing workshop. And then really to end Reconstruction, the last really major topic we have to talk about is how the South wins back seats in Congress. And that is a theme known as the redemption, the Redeemers, the Southern Redeemers. So we talk about that next week. Hope you guys have a great MLK Day off. Don't forget to spread the word about our friends we learned about on Friday, Hiram Revels and Joseph Rainey, the first two African Americans to serve in Congress. So take care. Hope you guys enjoy the rest of your weekends. The past shapes the future.